Hello and welcome to the Vista Lamão series of videos on Brazilian civil liability law. If you are doing business in Brazil, chances are that you will be exposed to some liability risk under local rules, be it torts or due to an alleged breach of contract. With that in mind, our dispute resolution team has carefully prepared a series of short videos about some key topics on how civil liability works in our country. We want to walk you through some basic elements involved in such claims from the perspective of a handful of legal regimes that our clients usually ask us about. More specifically, we will give you a bird's-eye view of civil liability in the fields of environmental law, misconduct in public office, product liability, and competition law. But first, I'm pleased to kick off our series with this episode, featuring a few concepts of civil liability law which are consequential for all specific legal systems to be covered in the next episodes. In Brazil, there are two main sets of rules on civil liability. First, there is a more general framework set out in the Civil Code, applying to virtually all disputes to a greater or lesser degree. Then, specific rules may take precedence in certain cases, such as environmental torts or consumer rights. Whatever the subject matter of the disputes, in order to hold the defendant liable for damages, the plaintiff must establish at least three elements. 1. An unlawful conduct on the part of the defendant. 2. The loss or harm suffered by the plaintiff. And 3. The so-called causation, the plaintiff's loss resulted from defendant's conduct. And, in many cases, a fourth element will have to be established as well, which is the defendant's fault, that is, its willful misconduct, recklessness, or negligence.
The unlawful conduct element consists of an act or omission that is in breach of the law. Crashing a car, for instance, is a wrongful act, while failing to repay a loan is a wrongful omission. As said, the second element is the loss or harm suffered by the plaintiff. To put it simply, this basically corresponds to the damages that the court should award to plaintiff. There are some types of damages in Brazilian law, such as compensatory damages, the so-called moral damages covering pain and suffering, personal injury, loss of profits, and so on. But keep in mind, Brazilian private law does not provide for strictly punitive damages. The amount payable to the plaintiff may not exceed the presumed or proven losses that it suffered. Third element is the causal connection between the unlawful conduct and the damage. This is what we call causation or causality. Essentially, the defendant's conduct must have been the sufficient and necessary source of plaintiff's loss or harm. In a nutshell, we are talking about establishing the appropriate cause and effect. The fourth and final element is defendant's fault, basically in the form of willful misconduct, recklessness, or negligence. It involves investigating whether the defendant could have acted differently or with greater care. Fault-based liability is the basic rule, but there are cases in which Brazilian law dispenses with this element. In these cases, we are talking about strict liability. Strict liability is the standard when it comes to claims for breach of contract. And when it comes to claims in torts, it also applies to consumer rights, environmental matters, and cases in which the business carried out by the defendant creates by its own nature risks to third parties. One example of that is nuclear power. So, that's it for now. Thanks, and please do watch the next videos in this series. Goodbye.